113300, State of Kansas v. Reddick.
May it please the court, counsel. My name is Corey Call, representing Andrew Reddick. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. Lena Keithley was found dead in a hotel room. They later determined that she had been asphyxiated, possibly smothered with a pillow. Mr. Reddick was subsequently arrested and convicted of first-degree murder and arson. The state alleged that he had smothered her and that he had then burned her automobile. About a week before the trial, the pretrial hearing, Mr. Reddick's counsel indicated Mr. Reddick wanted to waive his right to a jury trial, proceed with a bench trial. And the district court told him that he had a right to a jury trial of his peers. He didn't want to waive that. And he said he did. And we are challenging that, whether that was an insufficient advisement of Mr. Reddick of his right to trial. What actually happened was the defense counsel said that Mr. Reddick indicated to me that he was fearful that it would be difficult to find a jury that will not be prejudiced against him. And so then, as I said, the district court said you have a constitutional right to be tried by a jury of your peers in this community, and the court must provide that to you. That's really all the district court told him about his right to a jury trial. This court has been reluctant to set out any sort of bright line requirements of what a judge must say, and said that it depends on the facts of the particular case. So there's not aware of anything absolutely that the judge has to say. But the court has said that the court needs to be sure that the defendant was aware of the nature and extent of his rights. Now, a lot of times in these cases, we're sort of fishing in the dark as to why the defendant decided to waive this trial. That's not the case here because, as I said, his attorney said that he was fearful that it would be difficult to find a jury that would not be prejudiced against him. And then later, the prosecutor said, sort of sensing, I think, that the judge was a pretty brief colloquy, said, well, is he on any medications? Because that's a concern. And so the judge asked Mr. Reddick, and he said, no, I'm not on any medication. I just feel that the newspapers they got, when I sent the affidavit to the newspaper, all they seen was the arresting affidavit. They don't see two sides. They see one side, and they've seen that side several times, and therefore they'll never be able to know anyone else's side. They're always going to side with the law. Well, what that sounds like to me is that Mr. Reddick was afraid that the pretrial publicity had prejudiced the jury, and they were going to have prejudged him, and he would not get an unbiased jury, and therefore he wanted to try it to the judge, who he thought would be fair. But that's not how our jury trial system works. If a juror is prejudiced by the pretrial publicity, then the defense is able to voir dire the jury panel, and if the jury is biased, then they are struck. They're not allowed to serve. It's unclear that Mr. Reddick understood that, which is a key part of our system. And I'm not sure that the judge has to tell every defendant that he has a right to voir dire the witnesses or that he has a right to the presumption of innocence. But where the defendant says that I'm concerned that the jury is going to be biased against me, the judge at that point has an obligation to make sure he understands the nature and extent of his right to a jury trial and explain to him, well, but you understand you have the right to strike jurors, that jurors won't serve if they're biased. And we can ask them about their pretrial publicity, make sure they're not. That's part of the jury trial right. In State v. Beeman, that's what happened. The judge was talking to the defendant, and the defendant said one of the reasons why he wanted to waive his jury trial because he didn't want to put the family through a trial. And the judge stopped him and said, well, you understand that they're still going to testify to me. They're still going to go through the trial process. And the defendant said yes, which that's the proper way to handle it. You don't have to tell the defendant that the witnesses, the victims will still have to testify like that. But once it becomes apparent to the district court that the defendant doesn't understand the nature or extent of his right to a jury trial, that in a bench trial, they're still going to have to testify. You still go through the process. There's just no jury there. Then the district court has an obligation to make sure that he understands that. and that wasn't done here.
Does someone waiving the right to jury trial have to give any explanation as to why he or she desires a waiver?
I don't think that the defendant is required to. I think the judge has to. The judge has to ensure that that the defendant understands the nature and extent, and where they do
Right,
give it.
right.
Where
That's really the key here. Is that there's an explanation as to what the waiver, what the consequences of the waiver is, not the desire to seek the waiver. Isn't that the real key to what the judge has to do in these?
is that he understands. Right. I think that's right. I think that's right. But where the reason why he's waiving it demonstrates that he doesn't understand the nature of the right and sort of the consequences of that right. I guess to the extent, maybe I misunderstood, maybe I misheard you, that he has to understand the consequences of waiving that. I think part and parcel of that is that he understands how those rights work. That he's going to have this is when it's going to occur during a jury trial. And if this court finds that that he didn't waive it, then you move to the state has to show that it was harmless. And I think,
Mr. Kalk, before
yes.
we get there, I guess there's two things that are bugging me. The first one is this issue is being raised for the first time on appeal, so why don't you talk to us about why we should favor you with consideration of this issue. And then, but more importantly, in looking at the brief, the defendant's brief here, you talk generally about the defendant not knowing his many rights to the jury, but you never mention this whole voir dire process in your brief. You talk about whether the jury was unanimous, and so even if we were to favor you with considering this issue, how is it you didn't waive it? I mean, you can't be that general in this process, I don't think, at least. So
Sure.
hit me on those two.
Sure. First of all, with the right to that it's raised for the first time on appeal, the court has undergone kind of a shift from back in Luna. Originally, this court, there seemed to be a sort of bright line rule that you can't raise it. And lately in Fry and Beeman, the court talks about the importance of a jury trial, right? And that there's exceptions that has to be raised, can be raised for the first time on appeal. One of it is that it's the denial of a fundamental right. Certainly the right to a jury trial is a fundamental right. And the court talked about in Fry and in Beeman that the idea that, well, the defendant can't know what he doesn't know in this case, he wasn't advised of his rights. So the defendant's in a difficult position at that point to raise an issue when he doesn't know that the issue exists. And so in both Fry and Beeman and later Rizzo, it seems that the court has moved to generally accepting these issues raised, even though it was raised for the first time on appeal. And I guess I understand that the brief didn't talk specifically about the voir dire and the jury trial and the unanimity. And the unanimity is still an issue that you need to get into. And I think the unanimity I didn't address it, but it still plays into the idea of these, the fact that the jurors would be prejudiced, because if you believe that pretrial publicity, you could very well believe that a few of the jurors would be prejudiced. And we don't know if Mr. Reddick understood that the juries have to be unanimous. And so if you have a couple of jurors who weren't tainted, maybe they wouldn't be. We don't know that. But directly to your point, the issue that was raised was that he didn't understand his rights. And the brief didn't specifically talk about the voir dire, the jury trial, but I think it raised the question of whether he understood his rights. It included the portion of the record which talks about his reasons, and I think I'm just expanding on the reasons that were given in there. I'm giving an alternate I'm talking additional facts, but I don't believe it's an entirely new argument as far as that talking about the voir dire.
Well, under that rationale, you could just be saying he didn't get a fair trial and then show up at oral argument and try to specify why he didn't get a fair trial.
Well, I think we're a little bit more specific than that. I mean, there's a little small section that deals with the facts, which we specifically cite as like, this is the problem that we're having. This is the right that was violated. And I'm mentioning a different fact that supports that argument, but I don't know that it necessarily waived that argument. On the third issue, I would just mention, I believe the court in State v. Brown has already dispatched that issue. I'd be happy to discuss it if the court is perhaps prone to changing their mind on that issue, but it appears that was decided after the brief was filed. Unless the court has any further questions, we would ask that you find that he did not validly waive his.
Well, I do, on the second issue, that has to do with the sequestration rule.
Yes.
Correct. The witness that you intended, or the counsel intended to call, apparently sat in the courtroom the entire time.
Correct.
During the state's presentation. Did counsel know that they were going to call that witness at the time the witness was in the courtroom?
The record
is how did that work?
Sure, the record is pretty sparse on this point. Mr. Reddick is on the record as saying, "I told you I wanted to call a witness," and which we have that. We don't. There was the big problem with that issue is that there was no proffer of what the witness was going to say, or that I could tell even who the witness was going to be. So to answer your question, Mr. Reddick appeared to state that he had told his client that he wanted to call a witness, and I assume it was the same witness. So I would think that the counsel would have known that, but there's nothing in the record definitively stating it.
Speaking of a thin record, we don't have a proffer.
We don't have a proffer.
And do we even have an ID?
I did not see an ID of the witness, and that poses two problems. One, under 6405, it says that you can't reverse a judgment or vacate or reverse a conviction, vacate a judgment without a proffer for an evidentiary rule. Also, I think it's difficult for this court to do any sort of harmless error analysis without knowing what it's going to say. I would note that obviously this court can dispatch it and say the record isn't complete. However, under 405, the statutory limitation is very specific in that this court cannot reverse judgment or vacate a conviction. There's nothing to preclude this court under 405 from remanding it for a hearing. In this case, it seems pretty clear that the district court did not. The district court said witness was here during, we sequestered him, what was his here, can't testify. And that's not the proper analysis. There's more to the analysis than that. The judge needs to dig a little deeper in that. And so there's nothing under 405 to keep this court from remanding for a hearing, not vacating the conviction, not reversing the judgment, but remanding it for the judge to say, well, who was this witness, what were they going to say, and determining whether or not. So I understand this court on its own can say, no, it's your job to have a record, you didn't do it, therefore we're not going to consider this issue. But 405 doesn't preclude a remand.
Any further presentation?
No, Your Honor.
Do we have any more questions? Thank you, counsel.
Thank you.
It please the court, Rachel Pickering, Assistant District Attorney on behalf of the state. There were 3 issues raised in the appeal by the defendant. The third issue I may address, we believe has already been addressed this spring by this court, State v. Brown, regarding the sentencing. We believe that Mr. Reddick's life sentence should be upheld. That moves us to the first 2 issues, and both issues have something in common, which is preservation.
Before you go on the sentencing issue, there are multiple problems with the sentencing, not just the fact that Brown defeats a double. I mean, there was a criminal history score of C used on the arson, right? And that should have been I. So the sentence still has problems, right?
Right.
What do we do with that?
If it should be an I, and in that sentencing they said it should be C, you can remand that for resentencing on the I.
Okay.
And that should be a short
But
sentence.
wasn't it the other way around? They sentenced as an I and it
Should
should have
be a
been a
C.
C.
Oh, I thought it was a.
So,
Right.
Because they use the murder as the primary crime.
thing.
It's a be careful what you ask for.
Yeah, I was gonna say, I thought I saw C, and that's what I saw it as when I was going through this brief.
The offer was used as a base, which of course can't happen, and then
Right,
in addition, the wrong criminal history was used for the arson.
right. As long as the right, okay, I'll go with this answer. As long as the right criminal history is used in his sentence, that is the appropriate.
That's the problem, it wasn't, because it was not the base sentence when the sentencing was done. The arson was used as it
So,
was the other crime.
so it should, if it should be a C, that would make sense. Then he needs to be resentenced as appropriate.
Okay.
I'd like to start then with the preservation issue. The challenge to Redrick's jury trial waiver was not raised below. Now, this court, we acknowledge in our brief, has addressed this before in another case, but that was in 2012. And since then, this court has really...
How does that work? How do we require a defendant to object to the district court's failure to properly explain the rights that's being waived when the defendant didn't understand that he or she didn't get the full explanation? How is that defendant supposed to object to, I didn't get information on what I don't know?
The defendant could say what you just said, I don't understand. And here he understood.
If they don't understand that what they've been told is not complete, how
Right.
is it they can object to that?
Well, he has a defense counsel who was there, present at the hearing, who knows, defense counsel knows what rights the defendant.
Well, we've said the defendant has to waive the right to a jury trial. The counsel can't waive it for the defendant. Haven't we said that?
You have, yes,
So
absolutely.
this is a personal waiver. And
If-
so I'm still unclear of
Well-
how do you know what you don't know?
Well, my argument is those two should be separate. A personal waiver from the defendant does not mean that he alone has to object that it's not proper. And let me go through the timeline. He waives this a week before the bench trial. So he has all week, defense counsel has all week, they have the bench trial, and 2 months later they have sentencing. So in that period of time, defense counsel who was present at that hearing could have raised that issue, and it wasn't raised. So I understand this court's point of the defendant is the one who has to waive it, but we would argue if it's going to be addressed below, the defense counsel can put forward that as well. He is protecting the defendant's rights, and so we can't just put all the burden on the defendant.
So
And
it
if we-
wouldn't be a issue for direct appeal, it would be a 1507 for ineffective assistance of counsel for not explaining that he didn't get.
I don't know if
The
there's case law on that, but that is a suggestion of where this could go.
That was my question.
And by no means are we arguing that he's ineffective. What we're arguing is it wasn't raised. And the defendant at the end tells the judge why he's doing this. But the preservation issue, not raised below in the first one. In the second issue, I'd like to address the preservation when I get to that. But with respect to this first case, his waiver, we start with Irving. In 1975, Irving said, "We hold that in order for a defendant to effectively waive his right to a trial by jury, the defendant must first be advised by the court of his right to a jury trial." And that's what happened here. And he must personally waive that right in writing, in writing or in an open court for the record. And that's what happened here. So that district court did follow Irving. Now, he complains that he didn't properly advise him. And I note the point that Justice Breyer brought up, which is in the defendant's brief, page 6. In this case, the district court did not inform Mr. Redrick of many of his rights related to his right to a trial by jury of peers. And I read that and I thought, what rights are those? What rights are they talking about? This court has found in Beeman, which is cited in our case, that not informing the defendant, a 12-person jury would need to be unanimously agreed in order to convict him. This court said, no, you don't have to go that far. If that issue had been properly briefed, the state could have cited State v. Lewis, where the defense counsel said, hey, this defendant is waiving his right to a jury trial because he thinks he can't get a fair jury trial in Johnson County. The district court judge should have advised him of his Batson rights. And this court said, no, you don't have to do that. He understood his rights, and that's the important thing.
What does the court have to do?
We would argue it would have to do what it does here. Advise him of his constitutional right to try by jury, a jury of his peers. Peers in this community, she tells him, and the court will provide that to you. So those 4 things, she does advise him of those. So we would argue that that is important, that he understands that. So that advice right there.
So there's no responsibility to be responsive to any expressed misunderstanding. That's what your opposing counsel is really arguing here, is that what you've described might be okay in the ordinary case, but then here in the transcript, although I note it wasn't cited, this portion wasn't quoted in the defense brief, here the transcript continues, and the defendant, when asked about medication, says, no, the reason I'm doing this is I don't think I can get an impartial jury in these parts given the pretrial publicity. So at that point, there's no responsibility on the part of the trial court to say, no, you're mistaken about that. This is how we fix that or prevent that.
Well, this court found in Lewis that that step was not required.
Had the defendant
He had
indicated
said-
some misunderstanding in Lewis?
Not a misunderstanding. Here, I think it's very clear to the defendant, he doesn't think he can get a fair trial.
Right.
In
Fair jury trial.
Fair jury trial. In Lewis, he says the same thing. He's an African American in Johnson County. I don't think I can get a fair trial. Thinks he's going to get an all-white jury, is basically implied. And this court said, no, you do not have to go that far. In fact, he explains, I believe his explanation is important because this court in Clemens said, whether a jury trial has been knowingly and voluntarily waived must be based on the facts and circumstances of each case. And we believe that he clearly understood the benefits of not having a jury trial, but go to a bench trial. He understood that he gets to preserve his issue on appeal if he goes to bench trial. He still gets to preserve that. And he also understood that he would have an impartial fact finder look at his case. The judge. The judge would look at his case and not a peers from the community. So in our argument is it was very thoughtful. In fact, the judge says that. I appreciate your explanation. That was thoughtful decision you're making in your defense. So to the defendant's mind, he's actually getting a benefit of having an impartial fact finder and someone who will be able to listen to his defense. So we would argue his decision was freely made, knowingly, voluntarily, not under duress, and we would argue that this case is distinguished from Fry, that he understood his decision very well. That moves us to the second issue. And the second issue has a proffer issue, again, preservation, where it wasn't proffered by the defense who was going to, proffered by the defense by what this witness was going to say. Now, it's very important in looking at this case that the burden, we would argue, the fault is on the defense. And this court has held in Johns, if it is anywhere in evidence show that the party who desires to call the witness knew and participated in the violation of the separation order, that the court should exclude the witness's testimony. Now here, the state brings in 28 witnesses. If you look at volume 11, page 2, there are 28 witnesses that the state sequesters. This isn't 2 witnesses that the witness heard. This witness heard all 28. So to have a witness sit there where, again, it's implied the defense knows this witness is going to testify, have them hear all 28 witnesses, never leave the courtroom for the entire trial, how is that not knowing that the witness is hearing all this evidence and participating by not excluding?
Ms. Pickering, you just did an excellent explanation of what the judge should have done, but I don't think the record tells us the judge did that. I think what the record shows us is that the judge didn't conduct any analysis, just treated exclusion as an automatic outcome when the sequestration order had been violated. So I'm just asking probably what's an academic question, given the proffer issue. But that's not how the judge is supposed to proceed when these events arise, is it?
Well, we would argue that she was not automatically excluded, this witness, because the prosecutor does say she's not qualified to testify, and the judge holds off on making that ruling. So we would argue that that is the reason why we don't believe she's automatically excluding this person, saying you don't qualify to testify. She does say, so that would be our implication of it's not an automatic.
I'm sorry, I'm just unclear on the facts, perhaps. The prosecution rises and says, that, no, Your Honor, the witness isn't qualified to testify?
Yes.
And then you said the judge holds off on making a ruling?
No, she says, Your Honor, the judge says to the defense, would the witness be someone who has been in the courtroom for all the testimony in this trial? Defense, she has been. So he knows right there she has been. Then states, do you request that I order this? Did you request that I did order the sequestration rule and all witnesses? Defense, I did. Court, state's response, is there any response? No, this is where I get to the qualification. The state says, I object to any witness testifying that would be offered in violation of the sequestration rule. My understanding is that this witness has seen the entire trial and she is therefore not qualified to testify. Court, I don't know if she's not qualified to testify. However, okay, so our argument there is right there, she's not saying that she's not qualified to testify.
I understand.
But then, if you read on, the court has made a ruling all witnesses would be sequestered and not to hear evidence. And we will deny, I'm going to deny the defendant's request for a witness to testify in violation of the court's order.
So you're relying on what was said by the prosecutor to have implicitly been the judge's reasoning. The judge doesn't say the reason other than there was an order and it was violated and therefore you can't have the witness. That's what the judge says.
Right, but I'm giving you, yes, that's what the judge says. But
Yeah,
I'm
so
looking
you're importing what the prosecutor said into the judge's head, which may or may not be the case. We don't really know.
I don't believe I'm going that far. What I believe I'm going is taking a look at the record and saying, hey, look, we have 28 witnesses coming through here. This judge has sat on the
I'm
bench.
understanding that it may have been an egregious violation. I'm understanding that there might be an implication that the defense tried to pull a fast one, which does have import on the analysis. I'm just suggesting that what actually came out of the judge's mouth doesn't indicate an analysis beyond there was an order, it was violated, you were excluded.
Well,
And that's all I'm asking. But as I said, it's probably academic given the proffer situation, so we don't need to belabor.
right.
Sounds like my colleague down here may have a question. I heard a
No,
noise.
it's even though there's a violation of a sequestration rule, that doesn't automatically disqualify a witness from testifying. It's still a discretionary call, and that's what I think Justice Byers pointing out. I just didn't see where there was any kind of discretionary ruling made on the violation of the order. It's not automatic.
Right. Right.
That's never been.
Right, and I guess I would argue, let's take a look at the questions that the district court judge asked defense counsel.
The other thing that troubles me, this was not a jury trial. Obviously, the first point, the first issue brought up is it's a trial to the bench. And what you're concerned about, I think, with the sequestration rule is tailoring testimony. If you're sitting there watching this, a potential witness then can perhaps tailor the testimony to whatever he or she thinks ought to happen. And with it being a trial to the bench, does that diminish any concern about that? Understanding that it's the judge that's the trier of fact, not a jury. And also, isn't that witness subject to cross-examination? So again, on the very fact that, well, weren't you present for 28 witnesses? That type of cross-examination that the state could do.
So
Does that change the analysis at all?
I think it actually helps our harmlessness argument. Because, and I'm jumping,
Yeah.
but I don't want to get to harmlessness yet till we clarify this shouldn't be raised, we don't find this error, but how credible will this witness be? now that the district court judge knows that this witness has listened to the entire trial, all 28 witnesses.
That's his point. That's his point. It's credibility is, once the witness's testimony comes in, that's not an admission decision, that's a weighing that happens
Weighing
after
decision.
the witness has testified, and he's suggesting that since it was a bench trial, we should have maybe less concern that the judge can not separate wheat from chaff in a way that we might be concerned with a jury. That's his only point.
That is a consideration. I believe I started with the sentence. I'll end if any necessary. Remand is necessary. Necessary said twice. We would ask it done so. Criminal history is very important in getting it done right at sentencing. With that, we ask this court to affirm his conviction, if necessary, to remand it for sentencing if the criminal history is incorrect.
Do we have any more questions? Thank you, counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
One thing the state said, which struck me, was that Mr. Reddick waived his trial because he wanted an impartial fact finder in the judge. And that was I felt that was my line, was that he should know that he's going to have an impartial fact finder if it's a jury. He didn't appear that to be the case, but that's part of the right to a jury trial. It's that the jury is an impartial fact finder, and he didn't think he was going to get that.
Is there anything you'd like to tell us about the sentence, having listened to the...
I don't know if we've abandoned that sentencing issue, or if it's in a legal sense. I think
Can we
was
say it's illegal without anybody actually focusing on it?
I think you've maybe done that before. It's
think
illegal
we
to be
have
correct any time. I would say if you're sending it back for a sentencing hearing, you could certainly talk about the sequestration and have them ask about that before sentencing.
Have we ever done that before on a failure of proffer? Do you have any case in which we've created a process?
No.
So if we created the process, it would be named after this case.
You can name it after
Exactly.
me. That would
And that
be better.
actually,
But-
and it would apply very broadly to
Yeah,
all
it-
kinds of things we're curious about on appeal when it's not in the record.
But as far as you were correct. They did the criminal history.
Counsel, did you have anything to say in regard to the Lewis case that was cited by your opposing counsel?
Yeah, well, I would say that in that case, it was the defendant expressed concern that he was going to, it was Johnson County, and he wasn't going to get, he's going to have the all-white jury. Well, it's not part of your right to a jury trial that you get a certain racial demographic. That's not part of your jury trial rights. And that's different than here, where he was concerned about the pretrial publicity would be prejudged on that. And that is part of your pretrial rights, that they're going to be, that you, theoretically, no juror will serve who has prejudged your case based upon pretrial publicity. So had the judge properly informed him about that right, then he might not have made that decision. Whereas if the judge had told him, well, there was nothing to inform him about his jury trial rights, because you don't have a right to an all-white jury or a certain
Or a
racial
non-all-white jury.
Yeah, or a
That's what
non-all-white
you're
jury.
saying.
Yeah, that's right. Yeah, exactly.
That's really not true. If the judge says, well, can you set aside that prejudging and be fair and follow my instructions? If they ask it enough time and get the veneer person to say, oh yeah, I could do that, then they would say it.
That's right, and certainly there, a knowledgeable and informed defendant could still say, well, I think the pretrial publicity is such that they can't be fair. But I think we have to be assured that the defendant makes that's a knowing decision, that he understands that if they're biased, they should be struck. The judge, and they may not believe that, they may genuinely believe they can be impartial, all that, but it has to be a knowing waiver. Which could be.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.